Hi guys, you're watching another video of IPTSE. Before diving deep into IP, let me tell you about IPTSE. IPTSE is Intellectual Property Talent Search Examination. Like we all have Science Olympiad, Maths Olympiad in our school days, this is one of its own kind of program in the form of IP Olympiad. This initiative has been taken to spread the awareness about IP to young students and professionals, both from academia and industry. Now, since our country is dealing with terrible times of pandemic, we wanted to understand more about the IP issues involved in vaccines. We have all somewhere agreed that vaccines are the only ray of hope to fight this pandemic, and therefore, three A's have become so much important in the present times. Three A's are accessibility, affordability, and availability to these vaccines. COVAX is that solution which aims for rapid, fair, and equitable access to these vaccines across the countries. It is one of the global collaboration and has the world's largest and most diverse portfolio of COVID-19 vaccines. It was launched in April by WHO, that is World Health Organization, and European Commission and France. Apart from WHO, it involves Global Alliance for Vaccines and Immunization, that is Gavi, Coalition for Epidemic Preparedness Innovations, that is CEPI, and UN Children's Funds, that is UNICEF. In October, India and South Africa have proposed to waive the IPR in the vaccine. Under this proposal, India and South Africa have sought temporary relaxations for IP, patents, and other such provisions laid out under the TRIPS agreement of WTO. Now, there are essentially two main views. One is the right to health, and other is the incentivization to innovators. On one hand, the patent holders have exclusive right to manufacture, sell, and use the vaccine or the drug for the entire term of 20 years from the date of filing of the patent. But such type of protection will hinder the wider accessibility of vaccine and prolong the pandemic. Therefore, the joint proposal by India and South Africa proposed a waiver from implementation, application, and enforcement of certain provisions of the TRIPS agreement, waiving IP rights like patents, copyright, trademark for prevention, containment, or treatment of COVID-19. Though the TRIPS agreement itself contains flexibilities that allow for a balancing of rights of the patent holder with the people's right to health, but it seems that these flexibilities are insufficient to deal with the present pandemic situation. Let us understand the legal basis behind it. Article 9.3 of the Marrakesh Agreement establishing the WTO provides that in the exceptional circumstances, the Ministerial Conference may waive an obligation imposed on a WTO member country by the WTO agreement or any other multilateral trade agreement. Also, the Article 9.4 of the WTO agreement states that Ministerial Conference, while granting the waiver, shall state the exceptional circumstances justifying the decision and the terms and conditions that shall govern the working of the waiver. The waiver should also have an end date and be reviewed annually by the Ministerial Conference if granted for more than a year. The waiver power enshrined in Article 9.3 and Article 9.4 recognizes that there may be certain emergency situations causing hardship to a member country when compliance with the WTO norms may not be feasible. There are examples of the WTO system in the past where it was provided collective waiver. Article 31F of the TRIPS agreement, which provides that a compulsory license should be issued on a patented drug predominantly for the supply of domestic market, was waived for exporting countries subject to the extent necessary for the purposes of production of pharmaceutical product and its export to an eligible importing country. Likewise, the obligation under Article 31H to pay remuneration to the patent holder is waived for the eligible importing country. To list the flexibilities, there is the provision of compulsory license, which is regulated by the Article 31 of the TRIPS agreement. But developing countries that can use compulsory license to produce patented drugs are always under pressure from the developed countries not to issue such license. We all have not forgotten the story of generic version of Bayer's cancer drug. To read more about it, you can refer the Patents and Patients blog and compulsory licensing blog on our website. The fact that first the waiver, followed by the amendment of TRIPS agreement, was needed demonstrate that the TRIPS flexibilities are not adequate in addressing all the situations of the drug scarcity. There are other flexibilities as well, such as voluntary licenses, that is, the licenses given by patent holders to the generic companies on mutually agreed terms. The AstraZeneca COVID-19 vaccine, for example, has been licensed to India's Serum Institute is an example of voluntary license. Therefore, it is legitimate that the benefits should be shared with the society at large. As the World Health Organization has rightly said, with a fast moving pandemic, no one is safe unless everyone is safe. Therefore, the global community needs to pull out all these stops, including a temporary TRIPS waiver. Additionally, Russia offers free technology transfer and financial support for capital expenditure to its COVID-19 vaccine manufacturing partners in other countries, including India. After giving approval for Sputnik vaccine developed by Russia, India has become the 60th country to approve Sputnik vaccine. It is believed that 850 million doses of Sputnik vaccine are going to be produced in India annually. Thank you for watching this video. Stay tuned for upcoming videos and stay safe. Take very good care of yourself and don't forget to like this video. Thank you so much.